If you've got a specific legal question or situation you'd like to see covered here, drop it in the comments, because that's genuinely where a lot of future topics come from. I read them, and some of the most useful specific videos on this channel started as exactly that kind of comment from someone dealing with a real situation, so don't hesitate. Whatever it is, I'd like to hear it. All right, let's keep moving. There are two people living in the same house. Maybe they're married, maybe they're roommates. Maybe one of them owns the place and the other pays rent. And one afternoon there's a knock at the door, and one of them answers it, and one of them says yes, come in, go ahead, look around. And the other one, standing 10 feet away in the hallway, says no, absolutely not. I don't consent to any of this. And in that exact moment, with two people giving two completely opposite answers to the exact same question in the exact same house at the exact same time, the legal system has to make a decision about which one of them actually controls what happens next. And the answer to that question is not obvious, it is not simple, and it is not the same in every situation. And getting it wrong, or not knowing the answer at all, can cost someone their privacy, their freedom, or their ability to challenge what happens next in any meaningful way. This is one of those topics that sounds narrow until you actually look at the case law sitting underneath it, and then it becomes one of the most genuinely complicated, most practically important things you can understand about how consent works in the real world of your own home. Because almost everyone who shares a living space with another human being is operating every single day under a framework they've never been explained. They don't know who has the authority to let someone in. They don't know whether their own refusal protects them if the other person says yes. They don't know what happens when the two of them disagree right there in front of officers, in real time, with real consequences forming around every word. Before we get into every layer of how this actually works, if you want to actually understand your rights instead of guessing through the most consequential decisions of your life, subscribe right now, because this is exactly what this channel is here to do. And quick note before we begin, this is legal education and commentary, not legal advice for your specific situation. And state law does add wrinkles to some of what we're going to cover, but the foundational principles we're building from apply across virtually the entire country. Let's get into it. Let's start exactly where this whole topic begins, which is with the concept of the home itself and what kind of protection it actually holds. Because you cannot understand the consent question without first understanding why the home is different from every other place this question could be asked. The Fourth Amendment protects against unreasonable searches and seizures, and the courts of this country, across decades of rulings, have consistently treated the home as the single most protected place under that framework. Not the car, not the workplace, not a hotel room, not the street, the home. The reasoning goes all the way back to the founding era, to a generation of people who had experienced firsthand what it meant to live in a world where officials could enter your home whenever they decided they had a reason to, and who built a specific, deliberate, structural wall against that experience for every person who came after them. I want to talk for a second about why I think content like this actually matters, beyond just being interesting to talk about. There's a real meaningful gap between people who have easy access to legal knowledge, whether through education, profession, or family background, and people who don't, and that gap has real consequences in real situations. It's not fair, and it's not something any individual video is going to fully fix, but I do think there's genuine value in narrowing that gap even a little, one plain language explanation at a time, for anyone willing to spend a few minutes actually learning something instead of relying on guesswork or half-remembered fragments picked up secondhand. That's the actual mission behind this, as unglamorous as that sounds, not to turn anyone into a lawyer, but to close the specific, practical gaps that leave ordinary people at a disadvantage in moments that matter. All right, let's keep working on exactly that with today's topic. That wall is not symbolic. It exists in actual, enforceable constitutional doctrine, and it is yours, regardless of whether you own or rent, regardless of what the home looks like, regardless of what neighborhood it's in, regardless of how long you've been there, or what your name is on the lease. That elevated protection is why the consent question matters so much in the home specifically, because without a warrant, the wall comes down only if someone who lives there invites it down. And when multiple people live there, and they don't agree, the question of which one of them controls that decision is not a minor procedural detail. It is the entire ballgame. So let's start with the simplest version of the scenario, and then build outward from there, because the complexity is real, and it's worth understanding it in layers rather than all at once. The simplest version is this. Two people live together, neither of them is suspected of anything specific. Officers come to the door, both people are home, and one of them is willing to let officers in, while the other is not. Under the older framework that governed this for a long time, courts generally applied something called the third-party consent doctrine, which held that any person with what was called common authority over a shared space could give valid consent for officers to search that space, even if other occupants hadn't agreed, even if other occupants actively objected. Common authority, in that framework, meant roughly that the person consenting had shared access to and control over the area being searched. Not necessarily that they owned it, but that they had legitimate, mutual access to it. So a roommate could, under certain readings of that doctrine, consent to a search of the shared living room. A spouse could consent to a search of a shared bedroom. The key was whether the consenting person had the kind of shared access that made their consent meaningful rather than fraudulent or pretextual. For a long time, this doctrine created a genuinely alarming situation for anyone who shared their home with another person, because it essentially meant that your Fourth Amendment protection in your own home was only as strong as the willingness of every other person you lived with to assert it on your behalf. If your roommate was cooperative or nervous, or simply didn't know they could say no, the wall came down, not because you agreed to it, not because a judge authorized it, but because someone else who shared your kitchen decided to let it happen. And then came a case that changed this in a specific, critically important way. The case involved a domestic situation where a woman called police, reporting she'd been assaulted by her husband. Officers arrived, the husband explicitly told them they did not have permission to enter, and the wife, who was also present, told them they could come in. Officers entered, conducted a search, found evidence, and the question that eventually worked its way through the courts was whether that evidence could stand, whether the wife's consent was valid and sufficient when her husband, standing right there, had explicitly refused. The Supreme Court ultimately decided, in that case, that when a physically present occupant expressly refuses consent, that refusal cannot be overridden by another occupant's consent. The critical phrase there is physically present. When both people are actually there, in the same space, at the same time, and one of them says yes and the other says no, the no wins. Not because refusing has more legal weight as a general principle, but because allowing the situation to work the other way would effectively nullify one person's Fourth Amendment rights based entirely on a co-occupant's decision, and the court decided that was not what voluntary consent was supposed to look like. This is a genuinely significant ruling, and it's worth sitting with for a moment before we move forward, because it actually gives you something real and concrete to hold on to if you ever find yourself in exactly this position. If you are home, if you are present, if you are standing in that hallway or that living room or that doorway, and another occupant of your shared home is saying yes while you are clearly, explicitly saying no, your refusal matters. It is not just a preference that can be outweighed. It is a legally recognized assertion of your Fourth Amendment rights that, under this framework, the other person's consent cannot override. And knowing that, right now, is worth something. Because a lot of people in that exact moment feel completely powerless. They feel like the decision has already been made because the other person said yes, like their own objection is just noise, like there's nothing they can do because their roommate or spouse or family member has already opened the door. But that's not actually what the law says. What the law says is that your presence and your refusal change the situation in a concrete, enforceable way. Now let's talk about the next layer, because this is where things get meaningfully more complicated, and where a lot of the real-world scenarios that actually play out in people's lives start to diverge from the clean, simple version of the rule we just walked through. The exception, and this is important, is the physical presence requirement, because the ruling that gives your refusal this protective force is specifically tied to you actually being there to assert it. The moment you leave the house, the framework shifts. And it shifts in a direction that is not favorable to you, and that very few people understand or anticipate until after it's already happened. Here's what that looks like in practice. You and your roommate share an apartment. You go to work in the morning. Officers come to the door while you're gone. Your roommate, who is home, answers, and your roommate consents to a search. Under the framework we've been building, your roommate has the authority to consent to a search of shared areas of your shared home, and your prior refusal, if you'd even made one at some earlier point, does not travel with you in your absence. Your objection has to be present in the room to function as an objection. It cannot be asserted retroactively from wherever you are when the knock happens. This is genuinely uncomfortable, and it's worth understanding why the law draws the line here, rather than somewhere more protective of the absent occupant. The reasoning, essentially, is that consent doctrine has always been built around the idea that people who share spaces necessarily share some degree of access and authority over those spaces, and that the act of voluntarily sharing your living space with another person involves accepting, on some level, that they have real, not theoretical, access to the areas you share together. Your roommate doesn't need your permission to have someone over to the shared living room when you're at work. The law treats officers in roughly the same position as any other person your roommate might invite into that shared space, at least from the standpoint of consent, though obviously a search is a different kind of intrusion than a social visit, and the evidence rules that flow from it carry much higher stakes. What this means practically is something worth thinking through carefully, because it has a real planning dimension that most people in shared living situations never consider until it's too late. If you are concerned about the possibility of a search of your shared space, being physically absent from your home when officers arrive is not a protection. It is, in one specific and very important way, a vulnerability. The person who controls the consent question in your home is whoever is actually standing there when the question gets asked, not whoever pays more rent, not whoever's name is on the lease, not whoever objects most strongly in principle. Whoever is physically present when officers come to the door. Now let's talk about what shared actually means in this context, because not every area of your home is treated the same way, and understanding the distinction between shared spaces and private spaces is one of the more practically important parts of this entire conversation. When courts talk about the authority to consent to a search, they're talking about authority over specific areas, not the home as an undifferentiated whole, and that distinction matters enormously. A roommate generally has common authority over spaces that both of you share and use. The living room, the kitchen, the bathroom if it's shared, a shared storage area. They do not generally have common authority over spaces that are exclusively yours. Your private bedroom with its own lock, a storage unit that only you access, a cabinet that is clearly and specifically yours in a way the other person has no access to. This means that if your roommate consents to a search while you're absent, and officers stay within the genuinely shared areas, the consent may well be valid. If officers move from the shared living room into your private locked bedroom, which your roommate has never had access to and does not have a key for, the consent that covered the shared areas does not automatically carry them into spaces that are clearly and exclusively yours. The authority to consent is bounded by the actual scope of access and control, not by the four walls of the apartment as a single undivided unit. Now, in practice, these lines can get blurry, and they often get litigated specifically because they're blurry. A bedroom that's nominally yours but that your roommate has been known to enter freely, a storage area you share sometimes but mostly use yourself, a car parked in a shared garage. These are the kinds of factual questions that get argued in courtrooms after the fact, which is exactly why the principles matter, even if the edges are fuzzy. The cleaner and more exclusive your actual use of a specific area is, the stronger your argument that consent to a search of shared areas didn't extend to it. The more mixed the actual access has been, the murkier that argument becomes. This also has a practical implication for how you structure your living space if privacy is something you care about, and especially if you're in a situation where you have reason to think your home might become the subject of scrutiny at some point. A locked bedroom door isn't just a social signal about privacy between roommates. It is a physically real marker of the boundary of your exclusive space, and it matters legally in exactly the same way it matters socially. A lock that only you have a key to does meaningful work in establishing the exclusive nature of your access to that space, even if it can't do that work retroactively after the fact. Let's talk about the spousal version of this scenario specifically, because it comes up constantly, and it carries some additional complexity worth working through carefully, particularly in situations involving domestic disputes, which is exactly the kind of situation where this question tends to arise in real time with real urgency. Married couples or long-term domestic partners generally share a presumption of common authority over a shared home that's at least as strong as, and in many jurisdictions stronger than, the authority presumed between roommates. The shared bedroom, the shared closets, the shared common areas, all of that is typically territory where either partner's consent is presumed valid. And in a situation where one partner calls police about a domestic incident and invites them in, and the other partner objects, you're back in the scenario we walked through earlier, with the physical presence question sitting at the center of it. If both partners are present and one says yes and the other says no, the no controls. If one partner has left, walked out, been taken somewhere, is being held in a separate room by other officers while the search is conducted, the physical presence question starts to get much more complicated, and it's in exactly these situations that the law produces outcomes that feel wrong and are sometimes successfully challenged afterward. The question of whether someone's effective absence because they were removed from the premises by officers themselves triggers the same rules as a voluntary absence is one of the genuinely hard ones, and it's worth knowing that these situations do get challenged and do sometimes succeed, which is part of why the documentation and the clear statement of non-consent matters even in moments that feel completely out of your control. Let's talk about something that deserves very careful attention: what the consenting person can actually authorize, even when their consent is valid, because consent to enter is not the same as consent to search, and consent to search one area is not consent to search everything. This is a piece of the framework that often gets lost in the rush of an actual encounter, but it is critically important for understanding what the boundaries of valid consent actually look like. When a co-occupant answers the door and says, "Come in," officers have consent to enter. That is not automatically consent to go through drawers, open cabinets, search closets, look under beds, or access any specific area that isn't part of the ordinary space they've been invited into. Consent to enter a shared kitchen for a conversation is not consent to search the kitchen. Consent to search the kitchen is not consent to search a bedroom. The scope of what a co-occupant's consent covers is determined by what a reasonable person in the circumstances would have understood that consent to include, and it can be limited explicitly. "You can come in and sit down, but I'm not giving you permission to search anything," is a thing the consenting person can say, and it means something. For the non-consenting occupant, this scope limitation is one of the few levers that still operates even when you're absent. If your roommate says, "Come in and look around," but doesn't specifically authorize a search of a particular space, and officers go beyond what the consent actually covered, that portion of the search may be challengeable as exceeding the scope of the consent that was given. This is a technical argument that requires a lawyer and happens in a courtroom, not on your porch, but it's real, and it's worth knowing exists. The practical implication here for the co-occupant who is in fact willing to let officers in, the one who says yes, is that specificity matters on their end too, even though that's not what this video is primarily about. If you say yes, and then immediately want to narrow what you've agreed to, you can say so clearly. "You can come in, but I'm not giving consent for a search of anything specific, just to come in and talk." That statement has actual legal weight and creates an actual record of what was and wasn't authorized, which matters for everyone who shares that space, regardless of whether they're present or not. Let's talk about the scenario where there's a genuine, clear disagreement happening in real time, right there in the doorway, with officers present, because this is probably the most emotionally charged version of all of this, and it's worth walking through what it actually looks like and what each person should be doing. You are home, your roommate is home. Officers knock, your roommate answers before you get to the door, or while you're still in another room, and by the time you arrive at the front, your roommate has already said yes, or is in the process of saying yes, and you want to clearly register that you are not agreeing. The first thing is to actually say it, clearly, calmly, specifically, out loud, in front of the officers, not to your roommate, to the officers. "I want to be clear that I do not consent to this search. I do not consent to you entering my home." This statement needs to be directed at the people whose authority it limits, not whispered to your roommate in a side conversation, not implied by your body language, not communicated through a look or a gesture. It needs to be spoken, clearly enough to be heard and understood, in a context where there is no question what you were saying and to whom. This feels uncomfortable. It feels like you're creating a conflict in your own home, possibly creating a conflict between you and your roommate in a moment that's already stressful, and possibly seeming difficult or suspicious to officers who are standing right there listening to the disagreement. All of those feelings are understandable, and none of them should stop you from saying it. The statement is what creates the legal record. The statement is what activates the protection. A refusal that is only felt but never expressed does not function as a refusal in any legal sense, and if this ever gets litigated afterward, The question of whether you consented or refused will be answered based on what was said and done, not on what you were thinking. What do you do after you've said it? You stay present. You don't leave the space. You don't retreat into a bedroom and close the door, because physically removing yourself from the shared area is, in a practical sense, closer to absence than to presence, and presence is the thing that makes your refusal operative. You remain where you can be seen. You remain where it is clear you are an occupant of this space, and if officers attempt to proceed past the threshold, you restate your non-consent once more. I want to be clear again that I have not consented to this search. And then you do not physically interfere with whatever happens next, because physical interference creates its own legal problems that dwarf whatever was at stake in the search itself. Non-consent and non-interference are not contradictions. They work together. You express clearly that you have not agreed and would not agree, and then you let whatever is going to happen without putting your hands on anyone or blocking anyone physically, because the fight over whether your non-consent was honored happens in a courtroom, later, with a lawyer, not in the moment it's happening in your home. The moment is for making the record clear. The courtroom is for using that record. Let's talk about what to do with your roommate or co-occupant in the aftermath, because this is an aspect of the scenario that people don't often think about in advance, but that matters a lot for what happens next. If officers entered based on your co-occupant's consent over your objection, the first conversation is not with your co-occupant. The first conversation is with an attorney. Before you discuss anything about what happened, before you review together what officers said and saw and found, before you have the argument about why your roommate said yes when they shouldn't have, talk to an attorney, specifically someone who handles Fourth Amendment and search and seizure issues, because the exact sequence of events and the exact words used on all sides are going to matter enormously for whatever comes next. Your memory of those events is most useful before it gets mixed up with someone else's account of the same events, and that mixing happens fast once two people start talking through what just happened. After you've talked to an attorney and gotten guidance on what you can and should say and to whom, you can have the conversation with your co-occupant about what happened and why it matters. That conversation is worth having, and it is worth having specifically because the situation you just experienced is exactly the one that can be prevented in the future by a simple, clear, 10-minute conversation about what each of you would do if officers ever came to the door again. Because one of the most underused tools in this entire area of law is a genuine conversation between co-occupants in advance about exactly this scenario, so that if it ever happens, everyone in the household knows what the plan is before the knock ever comes. Let's talk about that conversation specifically, because it is worth having in your actual life with the actual people you share your actual space with, long before any of this becomes urgent. The conversation doesn't need to be dramatic or alarming. It can simply be something like, I want us to be on the same page about what we'd do if police ever came to the door asking to come in. Here's what I'd want to happen. We'd ask whether they have a warrant, and if they don't, we'd both decline to give consent. Are you okay with that as a shared approach? That's it. That's the whole conversation. It's not a legal seminar. It's not a declaration of suspicion or paranoia. It's the same kind of practical, protective conversation that healthy households have about fire escape plans or emergency contacts. A conversation about what to do in a situation that might never come up, so that if it does, you're not improvising under pressure. The reason this matters so much is that the most common way the split consent scenario actually plays out is not through deliberate disagreement. It's through a co-occupant who simply didn't know they could say no, or who was nervous and defaulted to cooperation, or who made a snap decision in the 30 seconds between the knock and the open door. If the people in your household have talked about this in advance and made a shared decision about how to handle it, the risk of one person saying yes while the other would say no drops dramatically, because cooperation in this context is a choice, not an obligation, and once people genuinely understand that, most of them make very different choices. Let's talk about the landlord question specifically, because this sits adjacent to the roommate and co-occupant framework, and it's worth being clear about how differently it operates. Your landlord does not have the authority to consent to a search of your rented unit on your behalf. This is not a gray area. The relationship between a landlord and a tenant is a legal one that transfers to the tenant the right to occupy and enjoy the space during the lease term, and that right explicitly includes the right to exclude others, including the landlord, from entering without proper notice and without cause recognized by the lease and applicable law. A landlord who says to officers, "Sure, Go ahead and search the apartment while my tenant is at work is not giving valid consent because the landlord does not have the Fourth Amendment authority over that space that the tenant holds during the lease. Now, the landlord's ability to enter for specific, legitimate purposes, maintenance, inspections with proper notice, emergencies involving the property itself, is a different question and governed by landlord-tenant law that varies by state. But the idea that a landlord can walk through your door with police because they said it's okay is not how the law works, and if that ever happens, the fact that the landlord consented rather than you is absolutely a basis for challenging whatever follows. The wrinkle is the shared area question in buildings with common spaces. As we touched on earlier, a shared hallway, a shared lobby, a shared laundry room, these are not spaces over which any individual tenant holds the exclusive privacy interest that your actual unit carries. Officers moving through a shared hallway of an apartment building to reach your door is not the same as officers entering your apartment, and the building owner or property manager may have authority over those shared spaces that doesn't extend to your unit. The protection we've been discussing lives behind your apartment door, and it's at its full strength specifically there. Let's talk about what happens in situations where the consent question gets complicated by family relationships specifically, because the parent and adult-child version of this scenario is one that comes up with enough frequency and enough emotional weight to deserve its own careful treatment. Consider a situation where an adult child lives at home with a parent. In the parent's house, the parent is on the deed, the parent pays the mortgage, but the adult child has their own bedroom, their own belongings, their own established privacy in that space. Who has the authority to consent to what? The general framework still applies, but the specific facts matter more here than almost anywhere else, because the scope of authority really does depend on the actual arrangements and expectations of the household. If the adult child has a private bedroom that the parent generally does not enter, that the parent doesn't have a key to, where the adult child's belongings are kept and private life is conducted, the parent's authority to consent to a search of that specific bedroom is much weaker than their authority over the shared common areas of the home they own. The parent's ownership of the property doesn't automatically give them common authority over every private space within it, particularly one where the expectations of exclusivity and privacy are clear and have been respected over time. This is one of the scenarios where the actual facts of how people live together, who enters whose space, what the established norms are, whether there are locks, whether there are shared understandings about privacy, do a lot of work in defining what consent covers and what it doesn't, which is uncomfortable because those facts are known and established long before anyone thinks to be precise about what they mean legally. But understanding that they matter is the starting point. Let's talk about the college roommate scenario specifically, because it's a version of this that affects a significant number of people who've never once been given any framework for thinking about it. Two students share a dorm room or an off-campus apartment. Neither of them is on the other's lease necessarily, or both of them are. One of them has something in the shared space that they'd rather not have found. Officers come to the door. The other roommate answers. The dorm room scenario has some additional wrinkles because university housing sometimes involves different rules about inspection and access that are built into the housing agreement both students signed, and the university's authority over its own property creates a slightly different layer than a private landlord. This is worth understanding specifically if you live in university housing, because the framework doesn't disappear entirely. Your Fourth Amendment rights don't evaporate because you're living in a dorm, but the exact shape of them is affected by what you agreed to in the housing contract and by the specific rules your institution operates under. If you're in university housing and this is something you care about, reading the actual housing agreement is worth the time it takes, because it often says more than you'd expect about under what circumstances the university can enter, what notice they're required to give, and what happens when law enforcement is involved. For off-campus housing, the standard framework applies much more cleanly. Your roommate has authority over shared areas. They do not have authority over your exclusive private space. If they're present and you're not, the absence problem kicks in. If you're both present and you disagree, your clear refusal matters and protects you in the way we've described throughout this video. Let's talk about what to do if you find yourself in a situation where you come home to find that a search has already been conducted. Your roommate consented while you were gone, officers came and went, and you're only learning about it after the fact. The first thing is not to touch or move anything. Not because you're preserving a crime scene, but because the physical state of the premises after a search can itself be evidence of what was searched and how, and altering it before you've talked to anyone knowledgeable about what happened is the kind of thing that can complicate matters unnecessarily. Take photos. Take them systematically, of every room, every drawer or cabinet that appears to have been opened or gone through, anything that's been moved or displaced. Then call an attorney before you do anything else, before you call anyone, before you post anything, before you have a long conversation with your roommate about exactly what happened. The reason the attorney call comes first is that your legal options in this situation depend enormously on the specific facts. What authority your roommate had, whether officers stayed within shared areas, whether they exceeded the scope of whatever consent was given, whether any warrant was involved at any point, whether anything was taken and on what basis. And those specific facts are exactly what a competent attorney in this area is going to need to evaluate before any meaningful conversation about what to do next can happen. That evaluation cannot happen if the facts have been stirred up by a series of conversations that created confusion about the sequence of events, or if evidence of the search's scope has been disturbed before it's been documented. Let's talk about a specific phrase worth knowing and worth using in real time if this situation ever presents itself. And this is a phrase that serves you regardless of whether you're the person at the door, or the person arriving home to a situation already in progress, or the person standing in the hallway while your co-occupant is having this conversation. I do not consent to this search, and I want that clearly noted. That phrase does specific work. It creates a contemporaneous record of your position. It makes absolutely clear, in language no one can misinterpret as ambiguous, that your agreement was not part of whatever happened here. It is not aggressive. It is not an accusation of anything. It is a statement of your legal position, delivered in terms precise enough to be useful, brief enough to be repeatable without confusion, and clear enough that no account of the encounter afterward can reasonably claim you didn't say it. Say it calmly. Say it to whoever is present with authority. Say it once, clearly, and then say it again if the situation continues to develop in a way that might cast doubt on whether you said it the first time. Documentation of refusal is only useful if the refusal is actually documented, and documentation starts with the spoken word in the moment it's happening, long before any written notes or recordings enter the picture. Let's talk about recording specifically in this context, because the multi-person dynamics of the split consent scenario make recording even more valuable than it is in a single-person encounter, and that's already pretty valuable. When two people give conflicting accounts of what was consented to, what was said, what objections were raised, and in what sequence, a recording resolves most of that confusion in a way that competing memories cannot. If you have a doorbell camera, it is working on your behalf in exactly this scenario, capturing who said what to whom, in what order, from the moment the knock happened. If you don't have a doorbell camera, the conversation we're walking through here is a reasonable argument for getting one, because the specific vulnerability that the split consent scenario creates, the possibility that your co-occupant's consent will be treated as covering more than it should, or that your own refusal will be minimized or forgotten, is significantly reduced when there's an objective record of exactly what each person said. In most places, you are allowed to record encounters with police at your own front door. You don't need to announce that you're recording. You don't need permission. The recording happens, and it exists, and later it either confirms that everything was done properly, or it reveals that it wasn't, and in either case, its existence is better than its absence. If you're in a situation where you know something is being recorded, your phone, a camera, anything, you can note that out loud. I want you to know this conversation is being recorded. That's not a threat. It's a statement that creates its own additional accountability in both directions. Let's talk about what happens if the search uncovers something, and the question becomes whether the evidence can be used. Because the consent and refusal framework we've been building throughout this video is not just an abstract exercise in knowing your rights. It has direct, concrete consequences for what happens in a courtroom if evidence is found and prosecution follows. Evidence found during a search that was conducted based on consent that was invalid. Because it exceeded the scope of what was authorized, because the consenting person lacked authority over the specific area searched, or because a present occupant's explicit refusal should have controlled, may be challenged under what's generally called the exclusionary rule, which provides that evidence obtained in violation of the Fourth Amendment generally cannot be used against you in a criminal proceeding. This is a significant protection, and it is the downstream consequence of everything we've been discussing. The reason the words you say in the moment matter so much is that they determine whether this protection is available to you later. A clearly stated, on-the-record refusal from a physically present occupant gives an attorney a concrete argument that the search that happened over that refusal was constitutionally invalid, and that whatever was found during it should be excluded from any proceedings. A situation where both occupants appeared to consent, or where the non-consenting occupant never clearly said anything, gives that same attorney much less to work with, because the record doesn't support the argument, even if internally you knew you didn't want the search to happen. This is why the preparation matters, not because you're planning to commit crimes, not because you're assuming the worst about law enforcement, but because the people who know their rights and assert them clearly in the moment they matter are the people who have something to fall back on if things go wrong. The people who improvise under pressure and say nothing, or say yes when they meant no, or stand silently while their co-occupant agrees to something they'd never agree to themselves. Those are the people who find themselves in a courtroom with an attorney who has to build a defense out of almost nothing. Knowing the rules is not suspicious. It is not hostile. It is not evidence of anything other than paying attention to how the law actually works in real life. And every single person who shares a home with another human being is operating within this framework, whether they know it or not. Which means the only real question is whether they understand what it means for them specifically. Let's talk about some of the specific phrases worth having ready for the split consent scenario, because like the reference framework we've been building from throughout this entire video, specific language ready in advance is what works under pressure, not a general feeling that you sort of understand the concept. If your co-occupant answers the door before you get there, and you arrive to find officers in conversation, "Excuse me, I'm also a resident here, and I want to be clear that I do not consent to any search of this property." If your co-occupant is actively saying yes while you're saying no, I understand my roommate is willing to cooperate, but as another resident with equal authority over this space, I'm explicitly not consenting. I want that on the record. If officers proceed despite your refusal, citing your co-occupant's consent, I understand you're moving forward. I want to be clear that I have not consented to this search. I am not consenting now, and I'm not going to interfere, but my position is that this search is happening over my explicit objection. If someone asks you about the space specifically, whose room is this, whose belongings are these, I'd rather not answer questions about the property without an attorney present. If you're the co-occupant who said yes, and you're now second-guessing whether that was the right call, even mid-encounter, I want to revise what I said earlier. I'd like to limit this to what we've already covered, and I'm withdrawing consent to search anything further. None of these statements are magical. None of them guarantee a particular outcome, but all of them create a record of where you stood, clearly and explicitly, at the moment it mattered, and that record is what everything that comes afterward is built from. Let's talk about one more layer that adds genuine complexity to the framework. What happens when officers have independent probable cause, separate from the consent question entirely, and when the consent question starts to intersect with the warrant exception framework we've covered elsewhere? The consent analysis we've been walking through matters most when officers have no warrant and are relying entirely on consent to authorize their entry and search. But if officers have probable cause independent of what anyone in the home says or does, if they observe something from outside, if they receive information from a reliable source, if they have independent grounds to believe evidence of a crime is present, they may pursue a warrant or invoke an exception to the warrant requirement on grounds that have nothing to do with whether you or your co-occupant said yes or no. In those situations, the consent question is less central, because consent is only one of the paths through the Fourth Amendment's requirements, not the only one. This doesn't mean your refusal becomes meaningless. It means the legal fight shifts from being purely about consent to being about whether the warrant or exception was valid, which is a different but equally important argument. In either case, the presence of your clear refusal in the record and the absence of anything that could be characterized as voluntary consent on your part is still valuable for preserving your ability to challenge what happened from the strongest possible position. Let's also be honest about something that sits at the edge of all of this, because this video has been about legal frameworks and legal rights, and legal frameworks don't always map perfectly onto what happens in real life in the way they look like they should on paper. The law says your presence and your refusal matter. The law says your co-occupant's consent cannot override your explicit objection when you're physically present. The law says evidence found in violation of that framework may be excluded. And all of that is true, and all of it is worth knowing. But the legal protection exists on the back end. It exists in the form of a motion to suppress evidence, filed by an attorney, argued in front of a judge, resolved weeks or months after the encounter itself. In the moment, officers may not fully comply with the framework we've described. Officers may proceed based on your co-occupant's consent over your objection. Officers may enter and search and find things before any of the legal arguments about whether they were allowed to gets made. The practical protection that flows from knowing your rights operates through what happens after, not through preventing the search from happening in the moment. Your spoken refusal is the evidence that supports the legal argument. The legal argument is what produces the exclusion of evidence. The exclusion of evidence is what changes the outcome of any proceeding that follows. The whole chain depends on the first link, which is the words you say clearly and explicitly in the moment the search is happening, no matter what comes next. This is not a reason to feel helpless. It is a reason to understand exactly where your protection actually operates, so you're not standing there expecting that saying no will produce an immediate stop to everything, and then feeling powerless when the encounter doesn't work that way. The framework is real, the protection is real, it just operates downstream, which is exactly why the upstream piece, the clear, recorded assertion of your position in the moment, cannot be omitted. Let's pull all of this together, because we've covered a lot of territory, and the clean summary of where we've landed is worth having in one place. Two people in the same home, one says yes, one says no. Which one controls? When both people are physically present and one clearly refuses, the refusal controls. That is what the law says, and that protection is yours to assert by saying it clearly, specifically, to the people standing at your door, in terms that leave no room for ambiguity. When one person is absent, the present occupant's consent may well be valid for shared areas, and the absent person's preferences don't travel with them when they leave. The protection is tied to presence, which means being home, staying present during the encounter, and making your position explicit in the moment, rather than in retrospect. The scope of what any co-occupant can consent to is bounded by the actual authority they have over the specific. Before I let you go, I want to say one more time that understanding your rights clearly isn't a small thing, even when the specific topic feels minor on the surface. It's the difference between navigating a real situation with confidence and navigating it with anxiety and guesswork. And that difference matters more than people usually realize until they're actually standing inside a moment where it counts. Thanks for spending this time building that understanding with me today. I'll see you in the next one.